Lauren with MtMv Voices, and this is part of the MtMv Voices and Friends for the Community by the Community series. And I am honored today to be chatting with Kendra Long from Northwest Women's Injury Law in Washington State. And she's going to talk a little bit about the survivor-lawyer legal relationship, and we have a slew of good questions that people have already reached out and asked us. And if you have any, please feel free to ask us. So for now, I'll go ahead and pass the floor over to Kendra.
Hi, everybody. So my name is Kendra Long, and I am the founding attorney at Northwest Women's Injury Law. We are a law firm in Washington State dedicated to representing women who have been injured. Injury comes in many forms, as we all know, and we have the gamut of cases. So I'll start out by saying that most of the survivors that I see, I'm working with in a different legal context. So survivors come into the legal system at multiple different times. Sometimes they're coming in because they are filing civil claims against their abusers or the institution where perhaps their abuser worked or had access to them. Sometimes they're going into court for orders of protection, and I see survivors in that context. Sometimes we see survivors in different contexts too. So sometimes I see a woman who has been in a car accident, and then she now has PTSD from an injury from a car accident, from that trauma. That trauma is then compiled on top of a childhood trauma, and at the end, even though I'm representing her for a car accident, I'm representing her truly for all of those things. Like, I'm that trusted person that gets to work with her and guide her through this really scary, really unknown legal system. I was just telling Lauren that one of the things is in hearing questions that people ask is some of the questions I don't even think about anymore because they're so common for me. Like, there's just something that I don't think about, but they're really important to people who don't know about the law. So I'll tell you a little bit about how to find an attorney if you need one, which is super important. And then I'll tell you a little bit about how you should work with your attorney, and we'll touch a bit on confidentiality because that's a really big topic for survivors too. So how to find an attorney. You want to know what kind of attorney you need. So if you were going to have a knee surgery, you obviously would not go to a cardiologist. If you need someone to represent you for a civil matter, for sexual assault, that is the kind of attorney you need to find. You don't want to find somebody who's just doing divorces or who's doing contracts because, all attorneys have a baseline minimum competency. We've all passed the bar, but everybody has specialist fields. Their specialties are really narrow. There's a lot of law to know in that. And so go to the type of attorney find. So that's the first one. So you can look for referrals either from support groups, from great resources in your community that support survivors. In King County, there's like King County Sexual Assault Resource Center. There's Dove on Vashon Island. There are a lot of great resources in our communities that have the ability to point survivors in the direction of somebody that they, to lawyers that can support them in a healthy way. You can ask friends that know. If ask friends, you can search on social media, you can Google attorneys, but the most important thing is that when you call them, that it is somebody who, one, understands your area of law, like they do practice in that area. And the other important thing is it's somebody that you feel like you can connect to, that you can be honest with, and that you can share your truths with. Because it does not help if you have an attorney and you feel like they're always rushing you off the phone, they don't listen to you. When you tell them that something's happened to you, they downplay it or don't believe you, or they're trying to come up with a justification for why that can't be, or why that can't be a problem. You need somebody who's going to listen to you and believe you. And if you have a question, to be able to answer that openly and honestly, both with the good that could be of that answer, but also some of the challenges that could be there. if they don't do that, then you just need to find another attorney, because there's a lot of us out there and somebody will be there absolutely to help you. And one red flag that I always caution people on is that if you're talking to an attorney and they are over promising you, if they are promising you the moon, that's a problem. If you're calling a law firm and you can't even talk to an attorney, also a problem. Like if they just want you to sign you up, but it's not an attorney even talking to you, then you want to definitely run away from that and find somebody else that can be a little more supportive, more understanding, more realistic in what your case is. You want your case to be more than a number. There's something else on that. Oh, what happens if the attorney doesn't want to take your case? Oh, this is a big one. Sometimes people call me, they have very valid cases. They're great women. I believe them 100%. I'm just not the right attorney for them, either because I'm too busy, I just don't have the time to dedicate to that matter, or that's just not, it's a super narrow area of law where I'm just not confident that I can get the best result. I try to tell them that. Other attorneys just say that they're not going to take the case. So if an attorney says that they can't take your case, don't try to guess why, because it's probably just that they're too busy or that's not their practice area, but they don't want to admit it. If they're not going to take it, just don't guess why. It's no reflection on you. It's no reflection on your case. It's no reflection on the validity of what you've experienced. It's just something that you need to take, say thank you, ask for a recommendation of somebody else to talk to, and then start the process over again. Call them, connect with them, see if you trust them, see if that's an area that they practice in. And if you can do that, then you're going to have a much better result, because you're going to find an attorney who wants your case, who really, really wants it. Let's see. I had something else here. Oh, working with an attorney. Most important thing, honesty. Just be honest. Be honest about all the good things that you think that your case brings. Be honest about all the areas that you see as troublesome or tricky or difficult. Because often what individuals see as problems in their case really aren't problems. They're just fears that they have about their case. For example, one reason that a lot of people don't report is that they've been using alcohol or drinking alcohol or using drugs at the time when they were assaulted. It isn't a legal problem from my perspective. Like people are worried about that being a problem, but from my point in the legal profession, it's not a problem for me. So just be honest, be open, tell me everything that you think that I should know. Give me honest answers to the questions that I ask, and just communicate about who you are. Communicate about what's potentially triggering for you if I'm working with you in a different context than directly related to an assault. So one example, and I always use this for my own personal life, when I was having my son, my abuser always called me nicknames. So he always called me this one nickname. I hate being called a nickname. I don't like it. I despise it. So when I was having my son, I specifically went to the hospital. I talked to the head nurse and I said, I don't like being called nicknames. So when you come in and I'm with the baby, don't say, hey mama, how are you doing? Or something like that. Because for me, that's really triggering because you've called me a nickname. So if you have things like that you know about yourself, just communicate them to your attorney so that they can support you and go out of their way to make sure that at other points in the legal proceeding, whether that be a mediation, an arbitration, a hearing, a deposition, that other people can also respect it, or at least they can minimize your exposure to it. Let's see. Last thing I'll touch upon before I answer questions is confidentiality. So lawyers have a duty of confidentiality. That means that we don't get to disclose what you tell us. Even if it's super juicy and exciting and interesting, we're not going to talk about it with other people. We're not going to tell other people who you are and your story unless you give us permission. So this confidentiality, this attorney-client privilege, it only applies if you are talking to me and there are not other people around who also don't have privilege. So that means if you come in and you're with your best friend for support and you want to sit in my office and tell me all these really deep things, that information is not protected because there was a third party there. If you come in with a spouse, of course, there's like a spousal privilege that applies, so then that information is protected. If you come in with a DV advocate or a sexual assault advocate from like a neighborhood organization or clinic, then of course, like that information is protected. But just generally, if there's third parties or you're telling me in an elevator as we're leaving court, that information is not considered protected. And while I can keep it secret, I keep it confidential, I may not be able to protect it from other people if they are truly trying to get at that. I can't prevent other people from going to tell what you've told me. I can't prevent that other person from being subpoenaed to tell what you told me. So it's just something to be aware of, like when you're moving forward. Okay. That's my legal spiel. What do we got the questions from?
That is great information. One question that I had is, if let's say you have one lawyer and it's not a good fit and that lawyer is helping you find another lawyer and the three of you are on a call, is that still protected?
That would be protected, yeah, because you're working in that context with a legal professional, and you're not, that's someone who that also has that privilege, that confidentiality. It kind of stops the bleed. So it's the same like if you were with your spouse or your clergyman, your reverend, your minister, if you're with them, like they also have that privilege. So it stops it. And people have attorney-client confidentiality and privilege with me, even when they call me on the phone and they're talking to me, they are talking to me for the purpose of representation. So that, even though I haven't represented them, and sometimes I don't, that privilege applies because that's why they've reached out to me in the first place. So.
Excellent, thank you. I have a list of questions that people submitted previously. We also have someone, let's start here. I'd like to know how to go about the legal process if your assault took place after being drugged and not having recollection until years later. And she is on the Zoom with us here now. So
yeah, so this is a really good question, and states deal with this in different ways. Many states deal with this in different ways. So in Washington state, for example, if you are under the age of 18, you have no recollection. Let's see, I'll phrase this in like a non-legal way. Okay, if you were under age 18 when you were assaulted in Washington state, but you don't remember it, or you don't realize the effects that it's had on your life, because some people remember it, but they don't tie the connection to anxiety or depression to that assault. So maybe that connection isn't made until years later. You have until 3 years after the date of that remembering or connection in your life to be able to bring that claim. If you were a child, if you were an adult, that is not necessarily the truth in Washington. So it gets more tricky. So it depends on your state. And there's a lot of great resources. So RAIN, which is the National Institute, National Assault, Abuse, Incest, Rape, Abuse, Incest National Network, right? RAIN, RAINN. They have a great state-by-state chart. So depending on what state you are in, you can go and look, because many states are starting to implement plans that if someone does not remember and remembers later, that they have opportunities to bring claims, but it's not in all states. RAIN, sorry, it's RAINN.org, I think. Rape, abuse by state charts. It will show, if you go to your state, it will show you like what the laws are in your state, both for criminal proceedings, but also for civil proceedings. It's really helpful. And then you can find, if you don't know, if you don't understand, you can go to your local sexual assault center. You can ask them. You can just ask them, like, this happened to me. Who can I talk to? And a lot of them have volunteer attorneys on site, or that you can make an appointment with to talk to. They can point you in the direction of somebody. And that's a question that if you just call a lawyer who practices in that area, they will be happy to answer that question about whether you have a claim or it's been too long. Because some people, unfortunately, they don't have claims that I can legally bring anymore because it's just been too long. Like, it's just not an option to bring them in court.
And that speaks to another question that just popped up in our group chat. Is it ever too late to report your assault? And I think that would go back to the state statute of limitations, correct?
Most states, for criminal matters, I think people should report no matter what. Because let's assume, if your assault happened 20 years ago at a school, and that person no longer works there anymore, maybe that person's dead, if you report it, then at least they know and they are aware that something happened. So if something else happens to somebody else, they already are on notice, and that they have the opportunity to take proactive measures to find ways to fix that shit, like to make sure that that does not happen to other people. So you should report it. You telling the police, even if they can't criminally prosecute it anymore, it's making a report that if something happens to somebody else comes forward, it is out there. It's still a public record. So yes, I don't ever think it's too long to report. Sometimes it's too long for it to be prosecuted. In Washington State, for example, rape in the first degree, there's no statute of limitations on that. So if it happens, it doesn't matter when that person can come up on criminal charges, even if they find them 50 years later. But people should report because it makes it easier for other people going through the process. It gives validation. It informs the institutions that we're working with that there's problems, that people are able to be abused in those institutions. Like, so many abuses come out of schools or medical clinics. But unless somebody speaks up and says it, one, the person keeps getting away with it. And two, the institution itself can't change policy to make it not happen or happen less or less likely to happen. So yes, report.
So a question comes, can my abuser be arrested if he's in another country? He ran away.
Yes. Let me see here. So they can still put out arrest warrants, right? If they decide that this is a case that they're going to prosecute and they're going to arrest this person for abusing you, they can absolutely put out an arrest warrant. And some places, an arrest warrant can be sent to international authorities who can be on the lookout for this person. So if you know that they went to Spain, for example, they can have contact with Spanish police to try to find this person and send them back. There's certain places that are less cooperative who are not going to go out and look for people. Depending on the extent of the crime, the local police may be more or less motivated to get this person off their street. It's definitely harder. It's harder if they're a citizen of the country that they went to, then they have some protections from their own country to prevent them from being shipped off to another country for trials. So that can come into play too. But if someone who is a US citizen fled to England, it'd be a bad place to flee in my mind, but yeah, they could go pick them up there and ship them back to the US.
Ship him back.
They do. I mean, that's what happens. You get caught, you get sent back, and and then they know you're going to flee, so they don't love that.
I'm sure not. Excellent, thank you. These are a lot really good questions, so I appreciate you answering them. This question speaks to once you're already kind of in the thick of the legal process. Can you speak to the process of taking the stand, cross-examination, and what kind of evidence the case they would use against the victim? This particular question is, can they use outside evidence of the case against the victim?
Also a really great question. So you have to, when you're on the stand, they get to ask you basically almost, not anything, but almost anything they want. and they can ask you really tough questions. They can ask questions that are going to make you really uncomfortable. They're going to try to make you out to be a liar. They're just going to try to discredit you in any way they can. And it's their job. So they do have outside resources. So, for example, when you're bringing a claim against somebody, they can look at your psychiatric records or your medical history, your gynecological records, your employment history, your criminal history, your credit history, photographs, drawings, videos, psychiatric exams. Like, they can look at all these things and use all these things to try to make it seem like you're lying. And it really sucks. It really, really sucks. And many jurisdictions have worked really hard to make it very difficult for them to use a woman or a person, not just a woman, a person's past sexual history. But that can still get brought up in some cases too, like especially if you've already had sex with a person or had any kind of like physical relationship with the person who has abused you. But yeah, they can use a lot of stuff. The best way to be prepared for cross-examination is to have an honest discussion with your attorney about it. And if it's a criminal case, like, the prosecutor will help you. The prosecutor is probably assigned an advocate. They probably assigned an advocate to assist you, so that person will be able to be there that day to support you, to give you just the emotional support that you need and that you really crave then, and they'll prepare you. They're going to tell, by the time you've gotten that far in the case, an attorney will be able to say, here could be the sticky points of your case. These are going to be the questions that they're going to really hit you on, because you were in a psychiatric hospital on this day, so they're going to ask you about that. Or you have a history over here, and they're going to ask you about that. By the time you get there, you'll know what it is. And so it's just preparing and working to be able to tell your story in a way that gets your story across, and be able to answer those questions that, they're going to try to discredit you with.
Great, thank you. Along the same lines, this question, do backdates, photos of bruising, or journal entries help win custody?
So in family law, there's a number of things that can affect custody, right? But if we're looking merely from a domestic violence standpoint, in some states, history of violence with the mother doesn't necessarily predict a history of violence with children, for example. So they basically say, oh no, they can be a great parent, they only beat up the mother. In other states, that's not true. In my state of Washington, they look at a lot of different factors. But in this case, if you have videos of bruising, photos of bruising, journals where you've written about abuse that you've suffered, these are all evidence. It is all evidence because it was written at the time. These photos were taken. They are real and true. And you can testify with your own voice that you wrote that journal entry on that day. And every day you write in your journal, and every day you write about what happened that day. You're not, this journal entry dated, the 21st of April was not, based on some event that happened on, in 2014. So yeah, they're evidence. They can be used. They're certainly helpful in a case where custody is disputed and in flux.
Excellent. Are there certain ways to prove emotional or mental abuse?
Your experience and your own testimony is proof. It is evidence in a case. What has happened to you, how it made you feel, that's true. Records that you have working with other people, it shows that. If you've told friends things that have happened to you, that is evidence too. It's harder to show a picture. You can't show a picture of emotional abuse. It's very difficult. It's really difficult to show that. But it's not impossible. Like, these are things that are shown with our own testimony. They're shown by going to doctors and telling, psychologists, psychiatrists, your own primary care physician, if this is something that you're experiencing, talking to them about it and having it put in your medical records so that if it ever comes up later, at least in your records, it's charted there that you told somebody, you talked to them about it, you told them what was happening, and they will give you resources and support too. But it's a way to document it with somebody who's like a reliable, trustworthy member of the community that, like, for some reason juries believe over just the person saying it.
You've spoken to this a bit already, but what hard evidence is necessary and can't be hearsay?
So hearsay is something that someone else has said that hearsay is information that you got from somebody else that you're now saying is true. So I can't say in court, Lauren told me that, and use that for the fact that it's true, that what Lauren said was true. So your own testimony is very strong and very powerful. It is probably the best piece of evidence you have. You can collaborate your own testimony with other things, emails you've sent a friend, text messages you've sent a friend, medical records that you have, phone calls that you've made, like you can use, you can get your phone records and show, like, on these dates you were calling hotlines to get assistance because you couldn't leave your house, but you still needed some support there. There's physical evidence, like if you know that it's happened, if you're assaulted and you can go to the doctor and they can collect physical evidence, if that's something you're comfortable with, that is evidence. You just have to, your testimony, I think it's your most powerful evidence. And your testimony can always be corroborated by other things. It's just reporting it, telling it. Like, if you report it, there's usually a report at where you reported it, at the police, which is now evidence. This is a police report. If you are reporting it to an institution, if you filed a notice with your employer, if you, any of these things, those are all pieces of evidence that have come in that are there for you. It's really hard to know without it being, like, very fact specific.
I think that's really helpful. Thank you. We have another question chime in our chat. In Pennsylvania, the law says that recordings aren't admissible if the person doesn't know they're being recorded. Yes.
Yeah.
Can a rape be proven if the recording is the only evidence you have?
That's tough. So I'm not licensed in Pennsylvania, so I don't know all the ins and outs of their, like, recording statutes, because sometimes there's exceptions to them. Generally, no. Generally, the law is that, like, you're not allowed to audio record someone without their permission. So if you're in a state that is a very hardline rule, then you can't use that recording. There could be, it's not the only evidence. Like, you have your own testimony, your own ability to go to the police or to be able to tell them what has happened. They can take you seriously. I don't know if the police will listen to a recording. I wish I knew more. It's very rarely something the only piece of evidence. So I would say, even if you're in a state where you absolutely cannot 100%, no exemptions, no exclusions, nothing applies, it's not the only piece of evidence. There's always something else. I've never seen one case where there was only one piece of evidence.
That actually leads perfectly to the next question is, can you go to court with little to no evidence, or do you have to accept the loss?
Less evidence is harder. It's harder. And cases get really expensive. In this case, it'd be like, can you go to, like, in that question, I would assume that they're talking about a civil situation. So with criminal cases, the state brings those. Individuals don't get to bring those per se as the state, but it's beyond a reasonable doubt. Like, that's the super high standard people are held to be convicted. In civil cases, it is much, much, much lower. So it's kind of a more probable than not, like, kind of situation. But still, you, as the plaintiff, have a requirement to present evidence to like show that on a more probable than not basis, this has happened. Depending on what kind of evidence you have, it could be better or more useful. I won't say better, more useful or more powerful than other types of evidence. It's worth it. But there's other considerations people have to have when they're deciding to go forward, like accept this loss. Like, I feel like it's such a big statement, and there are some people who choose to go forward with civil cases because they want the victim or the perpetrator to be outed. They want their day in court. They want the community to know what's happened to them. There's a lot of good that comes out of going to court sometimes, other than just always winning. And there's also some negatives. Like, people could have amazing evidence and get 100% slam dunk case, but they don't want to go to court because there's a lot of fear and there's a lot of kind of downsides that people have to think about, like when they're deciding like whether or not they're going to like take that case and go to court, like a loss of privacy. They're going to have to out this person, like how much time this is going to take, what kind of loss of confidentiality they're going to have, people who may not support them anymore or who may blame them. Like, there's a lot of different factors in deciding whether to even do that in the first place. So even if your evidence is weak, there could be reasons why you still want to go forward. You want to put on your case with whatever you've got, and it matters to you, so it should matter. And there are cases where you just have the most slam dunk evidence, but you don't want that, and that's okay too. People process in different ways. People heal in different ways. People want different things.
Absolutely. Thank you. Next question. If a girl is sexually harassed, can she report that to the police? What would happen after?
Yes, you should report it to the police. If you were sexually harassed, you should 100% report it to the police. So what will happen is they'll take your statement, they'll gather all information from you, they will want to know when it happened, where it happened, what was happening, what you were doing, what the other person was doing. They will ask every question that they can possibly think of to get a whole complete picture. They want to know who this person is, what their relationship is with you. Do you know them? Have you ever had a relationship with them? They'll ask a lot of questions. A lot of them are personal. A lot of them digging kind of questions to see if you're being dishonest or elaborating, or just to see like if this is a reasonable report. And then they'll take your report and they'll investigate it, and they'll contact this other person, and they'll look at the evidence that they have, and they'll decide whether or not this is something that they're going to like recommend for prosecution. And sometimes they have amazing evidence against someone, and for some reason it's still not prosecuted. But a report is always good, because if this person pops up again in the system later, it's a report, like now you've created evidence for somebody else to be able to use, like it that's so important too, not just it's your case and you're the most important person to you, but sometimes helping people down the line is also such a great gift.
Absolutely. This next question is specific to New York, but I'm sure you could probably speak to it to a certain degree. What are the laws in New York City for video recording of a 12-year-old being raped? It's over 20 years ago.
I'm not a New York attorney. As a citizen of the world, I'd say I cannot imagine a jurisdiction in which that, in Washington state, for example, there is no statute of limitations on first-degree rape. There is no statute of limitations on rape of a child. Like a 12-year-old in every jurisdiction is going to be considered a child. Like in some jurisdictions, if you're 16, 17, 15, even some places, like you're kind of in this middle ground, but a 12-year-old's pretty much always a child. So I feel like that would be some pretty hardcore evidence. What kind of video, whether this person knew they were being recorded, is it, I mean, like obviously there's just prohibitions in most states against audio recording. But if you have a video recording, then that's different, right? You don't need the audio to see what's happening there. I think that it's absolutely something that should be brought to the police. It is absolutely something that they should investigate. Like, I don't know the laws of New York, but as a citizen of the world, I think that it's very significant. Yeah. And I think it doesn't matter the time that person, like, even if New York's laws do not allow that person to be prosecuted anymore, somebody should know what has happened and what's gone on. Somebody should know.
Absolutely. These are some great questions. Thank you again for, time with us.
I wish I was licensed in every state. I wish I was everywhere.
I have a few more questions, if you don't mind.
Yeah, of course.
Let's see. The next one, which I'm not quite sure exactly what this means, but you might.
Okay.
Sexual assault perpetrators be called to the law. I'm not sure what that means, called to the law. Do you?
I'm not sure either. I think that I feel like that would be a more British, like coming before the court. I don't know. I don't actually know. I'm sorry.
That's okay. I know we spoke a little bit about this previously, but advice on safe ways to save and hide money for your escape.
Yeah. So in Washington State, if you were married to someone, 50% of what is yours belongs to them, and 50% of their stuff belongs to you. It's a community property state. This is a model that a lot of states have moved to. So if it's, obviously check your state. So as an attorney, I could never say, oh yes, go take $20 back, cash back every time you're shopping and stow that money away or keep it with a friend. Because then I'm asking you to like hide money from somebody who that legally is their money. So if you don't disclose that in a divorce, you're going to get screwed. On the other hand, you're going to get screwed if the person who's abusing you clears out your bank account and you don't have any money, and then you have to go fight them because they've cleared out your bank account and you have to somehow find money for that. So it's a really catch-22 situation. I would say that in that situation, everyone should follow the laws of their state. But I understand that people sometimes have to make the safest choices for themselves. And so everyone who is, if you're talking about leaving a spouse, I assume that you're over the age of 18 and that you're married and a competent legal adult to make that choice for yourself.
Thanks, Kendra. Let's see, we had a question just pop in our group chat. Would conversating to the perpetrator after my assault go against me and lessen my chances of getting justice?
So it'll definitely be brought up, because the idea, what they'll say is, well, why would you be talking with someone who assaults you? In reality, we know that people talk to people who assault them all the time. I had a friend personally who was dating somebody, and on their first date, he assaulted her, and then she continued to date him for 6 more months. She hadn't even started dating. It was their first date, but because she felt like, if you love me at some point, then you weren't raping me. And that's a really common scenario, is like, it happens. It happens all the time. So I would say that it's something that will be brought up. They'll be asking why you would want to communicate with this person who abused you. I think that any credible psychologist who works in this field would be able to get up on the stand and talk about the dynamics of healing, of victim mentality, even in why someone would choose to do that, even when they're assaulted, because it's really common. It happens. Like, because sometimes talking to them makes you feel, I don't know, it wasn't as bad or it wasn't as real, or sometimes you just have to talk to people too. Like sometimes they're the father of your child and you just don't have a choice, or sometimes you're in this social circle and you just, most people are abused by somebody they know. So sometimes you don't know what else to do. So you just talk to them at Thanksgiving or text them to see how the game went. It happens.
It is really common. It's a very common trauma response. And I think now more than ever, courts are beginning to have the trauma experts and the, psychologists that are explaining that dynamic.
Yeah, it happens. Yeah, it'll be brought up. But I think that it's really normal.
So this is one that is they're all interesting questions, but I've never heard this asked before. If you were legally an adult and your assaulter is a minor, could you still sue your assailant?
Yes. So children commit crimes all the time. I assume your assailant was not a 5-year-old, because there are certain children, like when you're really young, you don't have the mental capacity to commit crime. I assume that maybe you're an 18 or 19-year-old adult, and that the person who assaulted you was, a teenager as well at some point. So yes, crimes can occur. You can absolutely go after that person. They are absolutely responsible for their behavior. In criminal contexts, like children are tried as adults all the time, especially with sexual offenses. It's a thing that happens. If you're going after them in a civil situation, also still possible. There could also be, because sometimes you're going in a civil context, it's not always just going after the perpetrator. It's also going after other institutions that made that possible. So for example, if you're an 18-year-old senior on a class field trip and a 16-year-old boy, you're technically an adult at 18, the 16-year-old student assaults you. So it's not only the 16-year-old that's responsible for that, but also the school for negligent supervision of their students on a field trip. So it all depends on the context, but my general answer is that if this happened in Washington, that would be something that I would say yes. But like all my answers here today, I'm only licensed in Washington, so I can't speak to every state.
Understood. Well, I have one final question that came into us from previously from Instagram. And in the meantime, if anybody else who is here on the video chat wants to chime in, go ahead and chat your questions. This question is, what's the best advice you would give to domestic violence victims or sexual assault victims? Just in general, after the assault, and what they might want to do to help if they do want to take either criminal or civil action.
So my best advice is, I believe you. I care about you. I want things to be okay for you. As a legal professional, I can't make things go away. I can't make them not happen, but I can try to ease the burden of this on your life. So if you want, some people are ready to move away. They can't get away from their abuser. Sometimes it's harder. Sometimes they need more time or space. If that's you, that's okay. You find somebody that you can still talk to and that you can still trust, that you can still tell about what's happening, because the worst thing is to hide it. The same thing with sexual assault. The worst thing is to keep it secret, because it will literally eat you up inside. You have to be able to tell somebody. And maybe that's a psychologist, maybe it's a stranger on the internet, maybe it could be anybody, but you gotta tell somebody. So I believe you. I want you to be okay. I want you to be safe. If you're ready for that move, then you really need to find resources for yourself to help you do it, so that you can do it in a successful way that is not going to be more traumatizing for you. Because it can be really tough. Like some people, there's just a lot going on there. And so it's such a crazy time. So, Yeah, I guess I don't know what else to say about it. I mean, definitely like in that thing that they should find the resources to help them. If you go on and you do Google searches, like if you're Google searching and you're with somebody who is abusing you, obviously make sure that you're safely searching, clearing your browser history, searching in private mode, using a public computer instead of your own. But find resources in your community that'll help you, because your community is full of resources. And if you live in a tiny town in the middle of nowhere, then look at the next biggest city and look there, because there are a lot of community resources that you can call, you can reach out to, and you can ask for help, and they will help you with anything, like, or at least be able to point you in the direction of somebody that'll help. If you need housing help, they're going to be able to help you with that. If you need a family lawyer, they're going to be able to connect you with somebody who can give you some kind of advice or help you in some way. If you need help finding a therapist, like, they can connect you in different areas. Like, there's a whole network of people wanting to help people who are victims of abuse. And so if you need help, just reach out, because somebody will help you. Frankly, if anybody needs assistance and they don't know where to go, they can send me a DM, they can call me, they can email me. It doesn't matter. It doesn't matter what state they live in. I will find you somebody in your area to help you.
Thank you, Kendra. And same goes with me. I often have people reach out, DM me at Me Too Many Voices, and I help them find some local resources for their area. So there are helpers out there, and we're happy to help.
Yeah. The world's full of them once you know where to look. Sometimes it's just finding that initial contact and feeling safe and believed and supported.
100%. Looks like we have one last question here. Can you give a brief chronological overview of the court process? And are you referring to the criminal or civil court process? Do you mind?
Very important question.
Yes. Let's see if she will type in. She said, not sure if I were to report a sexual assault. So that would probably be criminal then.
So criminal, they'll take your report, they'll do some investigation. The police decide whether it is going to be reported then for prosecution. And once the prosecutor has it, the prosecutor runs with that. You're a witness in the case. It's not your case, but they navigate all that. I actually wrote down the numbers because I just thought it was so shocking. So out of every 1,000 rapes, only 384 of them are ever reported, which I thought was crazy. Only 57 of those that were actually reported led to an arrest. And what was the number? Oh, only 7 actually resulted in conviction. So the rest of them are pled out. The rest of them are dropped for whatever reason. Like, it happens. But in a criminal, proceeding, it's not in your hands. It's in the hands of the state. You don't get to decide. In a civil proceeding, it's a little bit different because you're hiring an attorney. Typically, your attorney would write a demand letter to this person, like, you've done this to my client. We want, all we can get is compensation in a civil case. All we can get is money. That's all I can get people. So we'd ask for that. And then if they don't respond to that or respond, sorry, I muted myself. So we'd send a demand letter. If they didn't answer the way we wanted, then we would file a lawsuit. And from there, we would do things like collect evidence, take depositions of people who may have information about this case. We would send over written questions to the defense, to the defendant and their lawyers. We would probably have mediation, and then you would have a trial. So it's a complicated, long process. And I'll say that even if you get a verdict and an award in a civil case, you can't always collect on it. Because let's say that you were assaulted, this person, a jury has decided owes you $100,000. Sometimes this person doesn't have $100,000 to give you. Most of the time, like, they don't have it. And so where are you going to get it from? Like, people try to declare bankruptcy, and that's kind of hit or miss, because usually you can't declare bankrupt out of judgments that are for things that are intentional, like sexual assault. But it can be really hard to collect on that judgment. So sorry, I know that was so complicated. A little all over the place.
This has been wonderful and informative. I feel like I'm walking away from this chat 110% more informed. So thank you very much.
Thank you.
Everyone for joining us. Again, I'm Lauren with Me Too Many Voices, and this is Kendra with the Northwest Women's Injury Law in Washington State.
Yeah. Thank you so much, Lauren.
Thank you. Talk to everyone soon.